The afternoon light comes sideways through the storefronts of downtown Cleveland, casting long, slanted shadows across Euclid Avenue. It's October 31st, 1963, Halloween, though the streets carry no trace of festivity, just the ordinary rhythm of a Thursday afternoon in the city's retail district. Buses pulling away from curbs, the metallic chime of shop bells, the shuffle of shoes on pavement worn smooth by decades of foot traffic. Detective Martin McFadden has walked this beat for 39 years. He knows the tempo of these blocks the way a conductor knows a score. The usual faces, the usual routes, the small deviations that mean nothing, and the ones that mean something. At 58 years old, his body carries the weight of nearly 4 decades in plainclothes patrol, but his eyes remain sharp, trained to read the grammar of the street in a language most people never learn to speak. Today, something catches his attention. 2 men are standing on the corner of Huron Road and Euclid Avenue, just outside Zucker's men's store. They're not shopping. They're not waiting for anyone. They're standing in a way that registers in McFadden's memory as wrong. Not dramatically, not obviously, but in the small, persistent way a note played slightly flat disrupts a melody. You're watching from across the street, though you don't yet know you're watching anything important. Just 2 black men in their 20s, dressed in long overcoats despite the mild autumn weather. One of them, the taller one, who will later be identified as John Terry, peers into the store window, lingers there a moment, then walks slowly down the block. His companion, Richard Chilton, remains at the corner. Terry walks perhaps a dozen storefronts down, pauses, turns, and walks back. The movement is casual, unhurried. He rejoins Chilton. They confer briefly, speaking close together. Then Terry does it again. Same route, same slow pace, same pause at the far end of the block, same return. McFadden has stopped moving. He's standing now against the window of a shop, partially concealed, his body angled so he can observe without being observed. This is the practiced stillness of a veteran detective, not hiding exactly, but becoming part of the scenery. 39 years have taught him to watch without watching, to see without being seen. The 2 men repeat the pattern. Terry walks, Chilton waits. Terry returns. They speak. Then Chilton walks the same route while Terry waits. The choreography is precise, repetitive, mechanical. Each man walks past Zucker's store window. Each man pauses. Each man peers inside. Each man returns to the corner where the other waits. They do this approximately 12 times. 12 times up the block, 12 times back. Each journey punctuated by these brief conferences at the corner, heads bent together, voices low. To anyone passing by, it might look like nothing. 2 men loitering, killing time, having a conversation. But to McFadden, the pattern has begun to calcify into something recognizable. He's seen this before. Not this exact scene, perhaps, but this rhythm. This surveillance disguised as idleness. A 3rd man joins them. He's white, wearing a light-colored overcoat, and he speaks briefly with Terry and Chilton before all 3 of them walk together up Euclid Avenue. McFadden follows at a distance, his shoes making no sound you can distinguish from the general shuffle of the sidewalk. The 3 men stop at a store, Hallie's, and the white man, later identified as Carl Katz, peers through the window in the same deliberate way. Then they turn and walk back down Huron Road, moving away from the commercial district and toward the residential streets that branch off into quieter neighborhoods. McFadden follows them for perhaps 10 or 12 minutes, maintaining his distance, watching the way they move together, the way they cluster and separate and cluster again. Finally, they stop outside a small shop at the corner of Huron and 14th. Katz goes inside. Terry and Chilton wait on the sidewalk, conferring again in that same close, quiet way. This is the moment McFadden makes his decision. He's a plainclothes detective. He carries no uniform, no visible badge, no marked authority. Just a man in street clothes approaching three strangers on a sidewalk. He later testifies that he suspects these men are casing the store, planning a robbery, and that he's concerned they may be armed. 39 years of experience, he'll say, have given him a sense for these things, an intuition, a feeling he cannot fully articulate but trusts nonetheless. He approaches them directly. You can see the moment his posture shifts from observer to actor. He walks up to the three men, identifies himself as a police officer, and asks their names. His voice is firm but not aggressive. Terry and Chilton mumble something unclear. Katz doesn't respond at all. The air between them tightens. McFadden later describes feeling a sense of danger, though no one has moved, no one has threatened him, no one has made any gesture that could be called hostile. He asks them to turn around. They hesitate. He asks again. Slowly they comply, turning to face the shop window. McFadden steps behind them. He doesn't ask for consent. He doesn't request permission to search. He simply reaches out and pats down the outside of Terry's overcoat, running his hands along the heavy wool fabric. He feels something, a hard object in the left breast pocket, not immediately identifiable through the thick coat, but present, distinct. McFadden reaches inside Terry's coat and removes a .38 caliber revolver, fully loaded. He does the same with Chilton and finds another revolver in his overcoat pocket. Katz, when searched, is unarmed. The entire encounter, from McFadden's initial approach to the discovery of the guns, takes less than 2 minutes. Terry and Chilton are arrested on the spot. They're charged with carrying concealed weapons. No robbery has occurred. No one has been threatened. No crime has been committed in McFadden's presence. The only evidence against them is what he found during the pat-down, a search conducted without a warrant, without probable cause as traditionally defined, and without the suspect's consent. The legal question forms slowly in the October air like a sentence being written one word at a time. If a police officer stops someone on the street based only on suspicion, not certainty, not evidence of a completed crime, just a trained intuition and a pattern of behavior, can he search that person's body for weapons? And if he does, and he finds a gun, can that gun be used as evidence in court? The Fourth Amendment to the United States Constitution protects citizens against unreasonable searches and seizures. It requires warrants supported by probable cause. It stands as a shield between the individual and the state, a barrier against arbitrary intrusions. But here, on this Cleveland sidewalk, that shield has been tested in a way the framers never explicitly addressed. Because John Terry and Richard Chilton were not searched because they were criminals, they were searched because they looked like they might become criminals. The line between suspicion and intrusion, between safety and freedom, between a cop's intuition and a citizen's rights, it runs through this moment like a fault line through stone. And the question trembles there, unresolved, waiting for the slow machinery of the law to grind toward an answer. The guns sit in evidence bags, the men sit in cells, and the case begins its long, quiet journey through the American legal system, carrying with it a question that will reshape the relationship between police and citizens for generations to come. The afternoon light fades over Euclid Avenue, and the streets empty slowly, leaving only the echo of footsteps and the weight of a decision not yet made. The Cuyahoga County Courthouse rises in pale stone above downtown Cleveland. its columns casting shadows across the steps where protesters and lawyers and witnesses pass each day. Inside, the corridors smell of floor wax and old paper, and the sound of footsteps on marble carries further than voices. This is where John Terry's case will be heard first. Not at the grand stage of the Supreme Court, not yet, but in a trial courtroom where the facts will be established and the questions will be framed. It's December 1963. 2 months have passed since the arrest. Terry and Chilton have been charged with carrying concealed weapons, and their attorneys have filed a motion to suppress the evidence, the revolvers, arguing that McFadden's search violated the Fourth Amendment. If the motion succeeds, the guns cannot be used at trial. Without the guns, there is no case. The outcome hinges entirely on whether the search was lawful. The hearing takes place before Judge Bernard Friedman in the Court of Common Pleas. The courtroom is small, functional, fluorescent lit. There are no spectators to speak of, no cameras, no press gallery. This is not a case anyone imagines will matter beyond these walls. Just another suppression hearing in a system that processes thousands of them each year. A routine dispute over police procedure in a city dealing with routine crime. Detective Martin McFadden takes the stand. You're sitting in the gallery, 3 rows back, watching his face as he settles into the witness chair. He's 58 years old, broad-shouldered, gray-haired, dressed in a conservative suit. His posture is upright but not stiff. He places one hand flat on the witness box railing, the other resting lightly in his lap. When he speaks, his voice is steady, practiced, the voice of a man who has testified many times before and knows the weight his words carry. The prosecutor asks him to describe what he saw on October 31st. McFadden's account is precise. He describes standing on the corner of Huron and Euclid, watching 2 men, Terry and Chilton, walk back and forth past Zucker's store. He estimates they made the trip 10 to 12 times each. He describes their movements as ritualistic, the way they paused at the window, the way they conferred between trips. He testifies that in his 39 years as a police officer, he's developed an ability to recognize suspicious behavior, and that what he observed that afternoon fit a pattern he associates with casing a store for robbery. The defense attorney rises for cross-examination. His name is Louis Stokes, a young black lawyer who will later become Ohio's first African-American congressman and a figure of significant moral authority in American politics. But here, in 1963, he's simply a criminal defense attorney trying to protect his client from what he believes is an unconstitutional search. His questions are sharp, methodical, designed to expose the thinness of McFadden's justification. Detective McFadden, Stokes begins. Did you see my client commit any crime? No, sir. Did you see him attempt to commit a crime? No, sir. Did anyone report a crime to you? No, sir. So when you approached Mr. Terry, you had no knowledge that any crime had been committed or was about to be committed. Is that correct? McFadden pauses. I had a suspicion. A suspicion, Stokes repeats, letting the word hang in the air. Based on what exactly? Based on their behavior, the way they were walking, the way they kept looking in the window, the way they talked to each other. Walking on a public sidewalk? Yes. Looking in a store window? Yes. Talking to each other? Yes. And these actions, walking, looking, talking, led you to believe they were planning to rob the store? McFadden shifts slightly in his seat. In my experience, yes. Stokes takes a step closer. Detective, Isn't it true that my client was doing nothing more than what any citizen has a right to do, walk freely in a public place? He was doing more than walking. What was he doing then, specifically? He was casing the store. But you didn't know that for certain, did you? I believed it. Belief isn't the same as knowledge, is it? The prosecutor objects. The judge allows the question. McFadden answers slowly. No, he says. It's not the same. Stokes shifts his approach. When you approached my client, did you ask him what he was doing? I asked his name. Did you ask him why he was walking back and forth? No. Did you ask him if he was planning to commit a crime? No. Did you ask his permission to search him? No. You simply reached into his coat and took his property. I conducted a pat-down for weapons. Without his consent. For my safety. Were you in danger, detective? McFadden pauses again. This is the question the entire case will turn on, though neither man knows it yet. I believed I might be. Based on what? Based on their behavior, based on my training, based on my experience. So you searched him, Stokes says, not because you knew he had a weapon, but because you thought he might have one. Yes. And if you'd been wrong, if there had been no gun, then I would have apologized and let him go. But you weren't wrong. No, sir, I wasn't. You watch Louis Stokes return to his seat. His expression is difficult to read. Frustration, perhaps, or resignation, or the careful neutrality lawyers learn to wear when they know the facts are against them. Because the facts are against them. Terry did have a gun. Chilton did have a gun. And no matter how many times Stokes points out that McFadden had no warrant, no probable cause, no legal justification under traditional Fourth Amendment doctrine, the practical reality remains. 2 armed men were stopped before they could commit a crime. Judge Friedman delivers his ruling from the bench. He denies the motion to suppress. The search, he concludes, was reasonable under the circumstances. McFadden had a legitimate concern for his safety. The pat-down was limited in scope, intended only to check for weapons. The guns were lawfully seized and can be admitted as evidence. Terry and Chilton are convicted. They receive sentences of 1 to 3 years. But Louis Stokes is not finished. He appeals the conviction to the Ohio Court of Appeals, arguing that the trial court erred in admitting the evidence. The Fourth Amendment, he insists, requires more than an officer's intuition. It requires probable cause, a reasonable belief based on specific facts that a crime has been or is being committed. McFadden had no such belief. He had a hunch. And in America, Stokes argues, hunches are not enough to justify government intrusions on individual liberty. The Court of Appeals affirms the conviction. Stokes appeals to the Ohio Supreme Court. The Ohio Supreme Court affirms the conviction. Each court agrees. The search was lawful. The conviction stands. The guns were properly admitted. McFadden acted reasonably. Terry and Chilton broke the law by carrying concealed weapons, and the fact that the weapons were discovered through a warrantless search does not render the evidence inadmissible. But Stokes continues. He files a petition for certiorari with the United States Supreme Court, asking the highest court in the land to review the case. It's a long shot. The Supreme Court receives thousands of such petitions each year and grants only a small fraction. Most criminal convictions end quietly in state courts, never reviewed by federal judges, never elevated to matters of constitutional significance. This one is different. The Supreme Court of the United States sits in a building of white marble and bronze doors, designed to evoke the temples of ancient democracies. Inside, the courtroom is surprisingly intimate, smaller than most people imagine, with mahogany benches and crimson drapes and a ceiling that arches high overhead like the vault of a cathedral. When the court is in session, a hushed formality settles over the space, as if the weight of history itself is pressing down on every word spoken. It's December 12th, 1967. 9 justices sit behind the bench, robed in black, their faces difficult to read from the gallery. Chief Justice Earl Warren presides from the center seat, flanked by 8 associates whose legal philosophies span the spectrum of American thought. This is the Warren Court, famous, controversial, transformative. Over the past decade, it has reshaped constitutional law, expanding civil rights, redefining criminal procedure, imposing new limits on state power. It has handed down decisions like Brown versus Board of Education, Miranda versus Arizona, Gideon versus Wainwright, rulings that have made the court both celebrated and reviled, depending on one's perspective. Today, it will hear arguments in Terry versus Ohio. You're seated in the public gallery, shoulder to shoulder with law students, journalists, curious citizens who've waited in line for a chance to witness this. The air feels dense with anticipation, though the courtroom itself remains perfectly still. No cameras are allowed, no recordings. Just the voices of lawyers and justices, preserved only in the official transcript and in the memories of those present. The attorney for John Terry rises first. His name is Louis Stokes, the same lawyer who represented Terry in Cleveland 4 years ago. He's traveled to Washington for this moment, prepared to argue that McFadden's search violated the most fundamental protections of the Fourth Amendment. He approaches the lectern, a small wooden podium positioned directly before the bench, and arranges his notes. When he speaks, his voice carries clearly through the chamber. Mr. Chief Justice, and may it please the court. This is the ritual opening, the formal phrase every advocate uses before the Supreme Court. It's a gesture of respect, an acknowledgement of the institution's authority, but also a kind of threshold, the moment when argument begins, when theory meets practice, when the abstract language of constitutional law confronts the concrete details of a street stop in Cleveland. Stokes begins by describing the facts. He recounts McFadden's observations, the pat-down, the discovery of the gun. Then he turns to the law. The Fourth Amendment, he reminds the court, protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. It requires that searches be supported by probable cause and, in most cases, by a warrant issued by a neutral magistrate. What Detective McFadden did that day, Stokes argues, was conduct a warrantless search based on nothing more than suspicion. My client was not committing a crime. He was not fleeing from a crime. He was walking on a public sidewalk, and yet he was stopped, searched, and seized, all without the protections the Fourth Amendment guarantees. Justice Byron White interrupts. His voice is sharp, precise, the voice of a former Deputy Attorney General who knows criminal procedure inside and out. Counsel, isn't there a difference between a full search and a limited pat-down for weapons? Stokes pauses. There may be a difference in degree, Your Honor, but not in kind. A search is a search. An intrusion is an intrusion. But the officer was concerned for his safety, White presses. Doesn't that concern matter? Of course it matters, Stokes replies, but concern alone cannot justify a constitutional violation. The Fourth Amendment protects all citizens, not just those who are innocent. If we allow officers to search anyone they find suspicious, we've effectively eliminated the amendment's protections. Chief Justice Warren leans forward. His voice is lower, more deliberate. What would you have had the officer do, Mr. Stokes? Wait until a robbery occurred? No, Your Honor. I would have had him observe, investigate, and, if he developed probable cause, make an arrest. But he didn't have probable cause. He had a hunch. A hunch based on 39 years of experience, Warren notes. Yes, Your Honor, but experience is not a substitute for evidence. The exchange continues, back and forth, the justices probing, testing, searching for the boundaries of Stokes's position. Justice Hugo Black asks whether police can ever stop someone without probable cause. Justice William Brennan asks what constitutes reasonable suspicion and how it differs from probable cause. Justice Potter Stewart asks whether the scope of the intrusion matters, whether a brief pat-down for weapons is different from a full search of pockets and belongings. Stokes answers each question carefully, but the tension in his argument is becoming clear. He's asking the court to rule that McFadden's search was unconstitutional, but if the court agrees, it will effectively prohibit police from conducting any stop and frisk without probable cause. And many of the justices seem reluctant to go that far. After 30 minutes, Stokes's time expires. He returns to his seat. The attorney for the state of Ohio rises next. His name is Reuben Payne, and he represents the government's position that McFadden's search was lawful. He's a seasoned prosecutor, familiar with the practical realities of policing, and his argument reflects that experience. Where Stokes emphasized constitutional principles, Payne emphasizes officer safety and crime prevention. Your Honors, Payne begins. This case is about whether a police officer, confronted with suspicious behavior and concerned for his safety, can take reasonable steps to protect himself. Detective McFadden did not conduct a search for evidence. He conducted a limited pat-down for weapons, and he did so only after observing behavior that, in his professional judgment, suggested an imminent crime. Justice Abe Fortas interrupts. But Mr. Payne, the Fourth Amendment doesn't have an exception for professional judgment, does it? No, Your Honor, but the Fourth Amendment prohibits only unreasonable searches, and reasonableness must be judged in context. An officer on the street facing potential danger cannot be held to the same standard as a magistrate reviewing a warrant application in the safety of chambers. So you're asking us to lower the standard, Fortas asks. I'm asking you to recognize that different circumstances require different standards, Payne replies. Probable cause is appropriate for arrests and full searches, but a brief stop and a limited pat-down for weapons, a Terry stop, if you will, should require only reasonable suspicion. Justice William O. Douglas, known for his fierce defense of civil liberties, interjects. And who decides what's reasonable? The officer? Initially, yes, Payne says, but subject to judicial review. That's circular, Douglas says, his tone skeptical. You're saying the officer can search if he thinks it's reasonable, and then a court will decide later whether he was right. But by then the search has already happened. Payne nods. That's true of any warrantless search, Your Honor. The question is whether, given the totality of circumstances, the officer's decision was objectively reasonable. The argument shifts. The justices ask Payne about the scope of the intrusion, the standard of proof, the potential for abuse. They ask whether allowing stops based on reasonable suspicion will lead to discriminatory enforcement, whether it will give officers too much discretion, whether it will erode the protections the Fourth Amendment was designed to provide. Payne responds carefully, acknowledging the concerns, but insisting that police cannot do their jobs if they're required to wait until a crime occurs before taking action. The Fourth Amendment, he argues, protects against unreasonable searches. It does not prohibit all searches. And in this case, Detective McFadden acted reasonably. The red light on the lectern blinks. Payne's time is up. He sits. The court takes the case under advisement. Months pass. Oral arguments are over. The transcripts are prepared. The justices retreat into conference, where they deliberate in private, discussing the case, debating the issues, casting preliminary votes. No one outside the court knows what's being said. No one knows which way the decision will go. You imagine the discussions behind those closed doors, the arguments, the persuasion, the drafting of opinions, the circulation of dissents. The court is deeply divided on many issues, and Terry v. Ohio cuts across ideological lines in complicated ways. Some justices who are typically protective of civil liberties may be sympathetic to the government's concerns about officer safety. Others who are typically deferential to police may be troubled by the erosion of Fourth Amendment protections. It's June 10, 1968, when the decision is finally announced. Chief Justice Earl Warren has written the majority opinion. He delivers it from the bench, reading key passages aloud in the formal tradition of the court. His voice is calm, measured, but the words carry enormous weight. The court holds that Detective McFadden's stop and frisk did not violate the Fourth Amendment. But it also holds that such stops are subject to constitutional scrutiny. They are seizures within the meaning of the Fourth Amendment, and the pat-down is a search. Both must be reasonable. And reasonableness, the court explains, depends on balancing the government's interest in crime prevention and officer safety against the individual's interest in personal security and privacy. Warren announces a new standard, reasonable suspicion. An officer may stop and briefly detain a person if the officer has reasonable suspicion, based on specific and articulable facts, that the person is involved in criminal activity. And if, during that stop, the officer reasonably believes the person may be armed and dangerous, the officer may conduct a limited pat-down of the person's outer clothing to search for weapons. This is less than probable cause. It's a lower standard. But it's not nothing. The officer must be able to point to specific facts that justify the stop. A hunch is not enough, nor is a generalized suspicion. The officer must articulate why he believed the person was engaged in criminal activity and why he believed the person was armed. The court emphasizes that the scope of the search is limited. It's not a full search for evidence. It's a protective frisk for weapons, nothing more. The officer may not search pockets or belongings unless he feels something that could reasonably be a weapon. The decision in Terry v. Ohio does not settle into silence the way most Supreme Court rulings do. It doesn't simply take its place in the volumes of case law, cited occasionally by lawyers, studied by law students, referenced in footnotes. Instead, it becomes something alive, a doctrine that moves through police departments and courtrooms and city streets, changing shape as it travels, interpreted and reinterpreted, expanded and constrained, until it becomes not just a legal principle, but a lived reality for millions of Americans. You're standing in a courtroom in New York City now, 8 years after the Supreme Court's decision. It's 1976. The room is crowded, fluorescent lit, institutional in the way all urban criminal courts are. Linoleum floors scuffed by decades of foot traffic, wooden benches worn smooth, the smell of old coffee and stale air. A suppression hearing is underway. Another weapons case, another stop and frisk. Another defendant arguing that the search violated his constitutional rights. The officer takes the stand. He's young, perhaps 27, dressed in uniform with his cap resting on the witness box beside him. When asked to describe the encounter, he speaks in the flat, practiced tone officers use when testifying, the voice that's meant to convey objectivity, professionalism, detachment from emotion. I observed the defendant standing on the corner of 125th and Lenox, he says. He was wearing a heavy coat despite the warm weather. His hands were in his pockets. He kept looking around nervously. Based on my training and experience, I believed he might be armed. The defense attorney rises. Officer, what exactly did you mean by looking around nervously? He was scanning the area, looking over his shoulder. People look over their shoulders all the time, don't they? Yes, but this was different. How was it different? It just was. I could tell. You could tell? Yes. Based on what specific facts? The officer pauses. Based on the totality of circumstances. This phrase, totality of circumstances, comes directly from Terry v. Ohio. Chief Justice Warren used it to describe how courts should evaluate whether an officer had reasonable suspicion. But in practice, it's become a kind of legal shield, a phrase officers invoke when they can't articulate specific facts, but want to justify a stop anyway. The totality of circumstances, everything taken together, a gestalt impression that resists precise description. The defense attorney presses. What was he doing with his hands? They were in his pockets. Is it illegal to put your hands in your pockets? No. Is it suspicious? It can be, depending on the context. What context made it suspicious here? The fact that it was warm outside and he was wearing a heavy coat. It was 60 degrees, officer. Some people get cold at 60 degrees, don't they? Some people do. So wearing a coat when it's 60 degrees is suspicious? Combined with the other factors, yes. What other factors? The way he was looking around, the fact that he was in a high-crime area. The defense attorney stops. A high-crime area? Yes. And where exactly is this high-crime area? Harlem. So being in Harlem is a factor that justified the stop? The prosecutor objects. The judge sustains. But the point has been made. Because this is what Terry has become in practice. A doctrine that allows officers to stop people not because they're doing anything illegal, but because they're present in certain neighborhoods, wearing certain clothes, moving in certain ways that officers have been trained to associate with criminality. The stop itself lasted less than 3 minutes. The officer approached, asked questions, felt the outside of the defendant's coat, discovered a bulge, reached inside, found a gun. The defendant was arrested, charged, convicted. The gun was admitted into evidence under Terry v. Ohio, which held that such searches are constitutional if based on reasonable suspicion. But what constitutes reasonable suspicion? This is the question that has haunted the doctrine since the day it was announced. Chief Justice Warren wrote that an officer must be able to point to specific and articulable facts that justify the stop. But in practice, officers have learned to articulate those facts in ways that courts almost always accept. Furtive movements, nervous glances, heavy clothing, presence in a high-crime area. These phrases appear in police reports across the country, repeated with such frequency that they've become formulaic, a kind of template for justifying stops that might otherwise seem arbitrary. And courts, for the most part, defer to officers' judgments. Because Terry also established that the question isn't whether the officer was actually right, whether the person stopped was actually engaged in criminal activity, but whether the officer's suspicion was reasonable at the moment of the stop. Even if the stop turns up nothing, even if the person was innocent, the search can still be lawful if the officer can articulate a reasonable basis for suspicion. You watch as the judge delivers her ruling from the bench. The search, she concludes, was constitutional. The officer had reasonable suspicion. The The gun is admissible. The defendant's motion to suppress is denied. The defendant, a young black man in his early 20s, shows no reaction. He's heard this before. He expected this. In neighborhoods like his, Terry stops are not abstract constitutional questions debated in law school classrooms. They're daily occurrences, encounters with police that shape the texture of ordinary life, that determine who gets stopped and who doesn't, who gets searched and who walks free. The statistics tell part of the story. In New York City alone, police conduct hundreds of thousands of Terry stops each year. In 2011, at the peak of the practice, officers will stop and frisk more than 685,000 people in a single year. Nearly 90% of those stopped will be Black or Latino. Nearly 90% will be found to have committed no crime and will be released without charges. The vast majority will never see the inside of a courtroom, will never have the opportunity to challenge the stop, will simply be detained, searched, and sent on their way. The Fourth Amendment, in theory, still protects them. Terry v. Ohio requires reasonable suspicion, but in practice, that standard has proven difficult to enforce. Because by the time a case reaches court, the stop has already occurred. The search has already been conducted, and the only people who get to challenge the legality of the stop are those who were arrested, a tiny fraction of the total number stopped. The rest simply disappear from the legal record, their encounters with police documented in department databases, but never reviewed by judges, never scrutinized by defense attorneys, never subject to the procedural safeguards the Fourth Amendment was designed to provide. Civil rights organizations begin to file lawsuits. The NAACP, the ACLU, the Center for Constitutional Rights, they bring cases challenging stop and frisk policies as unconstitutional, arguing that the practices violate both the Fourth Amendment's protection against unreasonable searches and the 14th Amendment's guarantee of equal protection under law. They present evidence showing that stops are concentrated in minority communities, that officers routinely fail to meet the reasonable suspicion standard, that the policy operates as a form of racialized social control. One case makes it all the way to federal court in Manhattan, Floyd versus City of New York. It's 2013, 50 years after Detective McFadden stopped John Terry on that Cleveland sidewalk. The plaintiffs, a class of individuals who were stopped and frisked by New York police, argue that the NYPD's practices are unconstitutional. The trial lasts 9 weeks. You're sitting in the gallery again, this time in a federal courthouse in Lower Manhattan, watching as witnesses testify to their experiences. Young men describe being stopped on their way to school, searched in front of neighbors, humiliated in public. Mothers describe watching their sons stopped repeatedly, 5 times, 10 times, 15 times, for no apparent reason other than being young and black and male in certain neighborhoods. Retired police officers testify about department quotas, about pressure to make stops, about training that emphasized aggressive enforcement in minority communities. Statistical experts present data showing that even after controlling for crime rates, stops are disproportionately concentrated in Black and Latino neighborhoods. The city defends the policy vigorously. The stops, they argue, are based on reasonable suspicion. They target high crime areas. They've contributed to a dramatic reduction in violent crime over the past 2 decades. New York is safer now than it's been in generations, and stop and frisk is part of the reason why. But the judge, Shira Scheindlin, finds the policy unconstitutional. In a lengthy opinion, she holds that the NYPD's stop and frisk practices violate the Fourth Amendment because officers routinely lack reasonable suspicion, and they violate the 14th Amendment because they disproportionately target minorities without sufficient justification. She orders reforms, enhanced training, better documentation, independent monitoring. The city appeals. The case becomes intensely political. The police union argues that the judge has handcuffed law enforcement, that crime will rise, that the city will become less safe. Civil rights groups argue that the ruling is long overdue, that stop and frisk has traumatized entire communities, that constitutional rights cannot be suspended in the name of crime prevention. Eventually, a new mayor takes office and drops the appeal. The reforms are implemented. The number of stops drops dramatically, from nearly 700,000 in 2011 to fewer than 50,000 in 2015. And violent crime continues to decline. But Terry versus Ohio remains the law. The doctrine itself has never been overturned. The Supreme Court has never revisited the fundamental question it addressed in 1968, whether police can stop and frisk individuals based on reasonable suspicion rather than probable cause. The framework established in Terry, the balancing of government interests against individual liberty, the authorization of brief stops and protective frisks, continues to govern police conduct across the country. And so the case exists in a kind of tension, suspended between competing values that have never been fully reconciled. On one hand, Terry recognizes a practical reality, that police officers work in dangerous environments, that they need some flexibility to investigate suspicious behavior and protect themselves, that requiring probable cause for every stop would make effective policing nearly impossible. On the other hand, Terry creates a category of police power that operates largely outside traditional constitutional constraints. It gives officers enormous discretion to determine who gets stopped and who doesn't. And that discretion, the evidence shows, is exercised in ways that reflect and reinforce existing patterns of racial inequality. The case that was supposed to balance liberty and security has instead become a flashpoint in debates about race, policing, and constitutional rights, debates that continue today in courtrooms and legislatures and city streets, wherever the question arises: when can the state intrude on individual freedom, and who gets to decide? The courtroom empties as the afternoon session concludes, lawyers gathering papers, defendants led back to holding cells, the machinery of justice grinding forward, case after case, each one a small variation on the same fundamental question. The street corner where Detective McFadden first observed John Terry and Richard Chilton no longer looks the way it did in 1963. Euclid Avenue has changed. New buildings, different businesses, the slow transformation that comes to all urban spaces over decades. Zucker's men's store is long gone. The people who walked these sidewalks that Halloween afternoon are older now, or gone, their lives having taken whatever paths lives take when a moment passes and becomes history. But the legal principle born on that corner has endured. You're sitting in a law school classroom now, decades removed from the original incident, listening to a professor explain Terry versus Ohio to a room full of first-year students. The case is taught in every criminal procedure course in America, presented as a foundational doctrine, a necessary compromise between competing constitutional values. The professor writes on the board, reasonable suspicion. Below it, specific and articulable facts. The students take notes, dutifully copying the phrases that will appear on their exams. The question Terry asks, the professor says, is how much intrusion the state can justify based on less than probable cause, And the answer is some, but not unlimited. The answer sounds clear in a classroom, but you've seen how unclear it becomes in practice. Because what does reasonable suspicion mean? What counts as a specific and articulable fact? How much weight should courts give to an officer's claim that someone looked nervous, walked suspiciously, reached toward their waistband? How do we distinguish between reasonable police work and racial profiling? These questions have generated thousands of cases, hundreds of appellate decisions, countless law review articles. Judges have tried to provide guidance, to draw lines, to clarify when a stop is justified and when it crosses into unconstitutional territory. But the line remains difficult to draw. Some courts have found stops unconstitutional when based solely on presence in a high-crime area, or solely on evasive behavior, or solely on an anonymous tip. Others have upheld stops based on combinations of factors that individually might seem innocent, but collectively, the courts conclude, create reasonable suspicion. The Supreme Court has revisited Terry several times, refining and expanding the doctrine in ways the original decision didn't anticipate. In Pennsylvania v. Mims, 1977, the court held that during a traffic stop, officers may order drivers to exit their vehicles even without suspicion that the driver is dangerous, a protective measure justified by officer safety concerns. In Michigan v. Long, 1983, the court held that officers may search the passenger compartment of a vehicle during a Terry stop if they reasonably believe the suspect is dangerous and may gain immediate control of weapons. In Minnesota v. Dickerson, 1993, the court held that if, during a lawful frisk, an officer feels an object whose contour makes its identity immediately apparent as contraband, the officer may seize it under the plain feel doctrine, an extension of Terry into areas Chief Justice Warren never explicitly addressed. In Illinois v. Wardlow, 2000, the court held that unprovoked flight from police in a high-crime area can contribute to reasonable suspicion, though flight alone is not enough. Each case adds another layer, another qualification, another exception or clarification. The doctrine grows more complex, more nuanced, more difficult to apply with confidence. What began as a relatively simple question, can an officer pat down someone for weapons based on reasonable suspicion, has become a vast body of jurisprudence governing a wide range of police-citizen encounters. And through it all, the racial dimension of Terry stops remains unresolved, because the statistics are undeniable. In jurisdiction after jurisdiction, study after study, the data show that Black and Latino individuals are stopped at dramatically higher rates than white individuals, even after controlling for crime rates, neighborhood characteristics, and other relevant variables. The New York experience is not unique. Similar patterns appear in Los Angeles, Chicago, Philadelphia, Baltimore, wherever stop and frisk is practiced extensively. Civil rights advocates argue that this is not a bug, but a feature of Terry, that the doctrine's flexibility inevitably leads to discriminatory enforcement because it gives officers too much discretion and too little accountability. When the standard is reasonable suspicion rather than probable cause, and when courts defer heavily to officers' subjective judgments, the result is a system that allows implicit bias and explicit prejudice to operate under the cover of legitimate law enforcement. Law enforcement organizations respond that officers are not racist, that stops are based on behavior, not race, that the disproportionate impact reflects differences in crime rates rather than discrimination. They point to the dramatic reductions in violent crime that coincided with aggressive stop and frisk policies in cities like New York, and they argue that removing this tool from police will make communities less safe. The debate is fierce, polarized, often conducted in language more political than legal. But beneath the rhetoric lies a genuine tension that Terry never fully resolved. How do we give police the authority they need to prevent crime and protect themselves, while also ensuring that authority isn't exercised in ways that violate constitutional principles or target individuals based on race? Some scholars have called for Terry to be overturned entirely, to return to a regime where stops require probable cause, where the Fourth Amendment's protections are not diluted by exceptions and qualifications. Others have argued for reforms that maintain Terry's framework but impose stricter limits on officer discretion, require better documentation, mandate data collection and analysis to detect patterns of discriminatory enforcement. Still others have suggested that the problem isn't Terry itself, but the way it's been implemented, that reasonable suspicion, properly applied, can coexist with constitutional protections, but only if courts take seriously their obligation to scrutinize police conduct rather than reflexively deferring to officers' judgments. The Supreme Court has not taken up these questions in any comprehensive way. Terry remains good law, cited in hundreds of cases each year, applied in thousands of encounters each day. The doctrine has proven remarkably stable, surviving half a century of criticism and remaining a cornerstone of Fourth Amendment jurisprudence. But the silence from the court on the racial dimensions of Terry stops is conspicuous. In case after case, defendants raise claims that stops were motivated by race, that officers targeted them because of their skin color, that the policy operates as a tool of racial subordination. And in case after case, courts reject those claims, finding that officers had reasonable suspicion based on factors unrelated to race, that any disparate impact is incidental rather than intentional, that the Fourth Amendment requires only reasonableness, not statistical parity. The 14th Amendment, which prohibits states from denying equal protection of the laws, theoretically provides another avenue for challenging discriminatory stops. But proving intentional discrimination is extremely difficult, requiring evidence that officers acted with discriminatory purpose, not merely that their actions had discriminatory effects. And courts have generally been reluctant to infer discriminatory intent from statistical disparities alone. So the practice continues, constitutional but controversial, legal but contested. You're back on a city street now, evening settling over the blocks, streetlights beginning to glow in the dusk. A young man walks past, hands in his pockets, headphones in his ears, moving with the unhurried pace of someone heading home after work. A patrol car rolls slowly down the street. The officer inside watches. The young man glances at the car, then looks away. The car continues past. Nothing happens. But the possibility is always there. The possibility that the officer will stop, will approach, will ask questions, will conduct a frisk. The possibility that this ordinary moment will become a legal encounter, governed by Terry versus Ohio, a case the young man has probably never heard of, but which shapes his relationship with police in ways he feels, even if he can't name. This is what Terry has become, not just a legal doctrine, but a social fact, a pattern of interaction that structures daily life for millions of people, particularly in communities of color. It's the knowledge that you can be stopped at any time for reasons you may never fully understand, subject to a search you cannot refuse, based on an officer's judgment you cannot challenge except in court, and only if you're arrested first. The Fourth Amendment was designed to protect against exactly this kind of discretionary power. The framers feared a government that could enter homes, search belongings, seize persons without warrants or clear legal authority. They wrote the amendment to establish a barrier between citizens and the state, a requirement that intrusions be justified by evidence and approved by neutral magistrates. Terry created an exception to that rule, a necessary exception, many believe, given the realities of modern policing. But exceptions have a way of becoming norms, and what was once a narrow authorization for protective frisks has expanded into a broad police power that touches millions of lives each year. The balance Chief Justice Warren tried to strike between liberty and security, between individual rights and public safety, has proven difficult to maintain, perhaps impossible to maintain, because the interests at stake are not easily weighed against each other, not reducible to a formula or a test. They're competing values, each legitimate, each compelling, each demanding recognition. And so the case continues to generate controversy, continues to be litigated, continues to be debated in courtrooms and classrooms and city councils. 50 years after the decision, 60 years after the stop, the question remains unresolved. When can the state intrude on individual freedom, and who pays the price when it does? The street empties as night falls, the young man turning a corner and disappearing from view, the patrol car moving on to the next block, the city settling into the rhythms that govern the dark hours, and somewhere in the silence between question and answer, the law continues its work. The legacy of Terry versus Ohio is written not in a single document but across decades of lived experience, in millions of encounters between police and citizens, in the slow evolution of constitutional doctrine and the faster shifts of social policy. It's a legacy that resists simple summary, that contains within it both practical wisdom and profound injustice, both necessary compromise and troubling precedent. John Terry himself served his sentence and returned to private life. He never became a public figure, never gave interviews about the case that bears his name, never commented on how his brief encounter with a Cleveland detective became one of the most consequential Supreme Court decisions of the 20th century. He lived quietly, worked, aged, and eventually died, leaving behind only the thin paper trail of court records and the single moment that made him famous. Richard Chilton, stopped alongside Terry that October afternoon, followed a similar path into obscurity. The case was always titled Terry versus Ohio, never Terry and Chilton, and history has largely forgotten that there were two men on that sidewalk, two guns discovered, two convictions challenged. Detective Martin McFadden continued his career in the Cleveland Police Department, retiring after decades of service. He too gave few interviews, maintained a low profile, and eventually passed away. In depositions and testimony, he always insisted he acted properly, that he observed suspicious behavior and took reasonable steps to protect himself. He never expressed doubt about the stop. He believed he prevented a crime that afternoon, and nothing in the subsequent legal proceedings changed his mind. Louis Stokes, the attorney who argued Terry's case before the Supreme Court, went on to become a congressman representing Cleveland for 30 years. He remained a fierce advocate for civil rights and criminal justice reform, often speaking about the need to constrain police power and protect constitutional liberties. He understood that he'd lost the case but won a measure of clarity, that Terry at least required officers to articulate specific facts rather than relying on pure intuition. It was a small victory inside a larger defeat. Chief Justice Earl Warren retired from the Supreme Court in 1969, a year after deciding Terry. His tenure had transformed American constitutional law, expanding rights for criminal defendants, protecting free speech, desegregating schools, and redefining the relationship between citizens and government. Terry fit awkwardly into that legacy, a decision that seemed to constrain police power, but in practice gave them new authority. Warren himself never expressed regret, but scholars have debated whether the decision was consistent with his broader judicial philosophy or a departure from it. The doctrine itself has evolved in ways that complicate any simple assessment. In some jurisdictions, Terry has been applied rigorously, with courts carefully scrutinizing stops to ensure they're supported by reasonable suspicion. Training programs have emphasized constitutional limits. Data collection has made it possible to identify patterns of discriminatory enforcement and hold departments accountable. Reforms have been implemented. Policies have changed. In other jurisdictions, Terry has become a blank check, a justification for aggressive stop-and-frisk policies that operate with minimal oversight and produce massive racial disparities. Officers are trained to articulate magic words, furtive movements, high crime area, officer safety, that courts almost never question. Communities experience these stops as harassment, as humiliation, as a reminder that they are presumptively suspicious in the eyes of law enforcement. The question is whether this is a failure of the doctrine or a failure of its implementation, whether Terry itself is the problem or whether the problem is the way police and courts have applied it. Some legal scholars argue that Terry was wrongly decided, that the Supreme Court should never have created an exception to the probable cause requirement, that the Fourth Amendment's protections should not bend to accommodate law enforcement convenience. They point to the millions of stops conducted each year, the overwhelming majority of which produce no evidence of crime, as proof that the doctrine has failed to serve its stated purpose while inflicting enormous costs on constitutional rights and community trust. Others argue that Terry was necessary and remains defensible, that police need the ability to investigate suspicious behavior before it escalates into violence, that requiring probable cause for every stop would make crime prevention impossible. They acknowledge the problems with implementation, but insist the solution is better training and oversight, not abandoning the doctrine entirely. The debate has never been resolved because the underlying tension has never been resolved. The tension between security and liberty, between community safety and individual rights, between the need to prevent crime and the need to constrain government power. You're standing outside the Supreme Court building now, years removed from all the previous scenes but connected to them by the invisible thread of legal doctrine. The marble steps are worn smooth by the passage of countless feet. Tourists take photographs. Law clerks hurry past with armloads of briefs. Inside, the justices are hearing arguments in another Fourth Amendment case, another dispute about police power and constitutional limits, another variation on questions that have been asked and answered and asked again since the founding. Terry versus Ohio will be cited during the argument. It always is. It's become one of those landmark cases that lawyers mention reflexively, a shorthand for a complex body of doctrine, a reference point everyone understands. But its meaning shifts depending on who's citing it and for what purpose. For some, Terry represents judicial pragmatism, a recognition that constitutional rules must accommodate real-world needs, that abstract principles must give way to practical realities, that the Fourth Amendment protects against unreasonable searches but allows reasonable ones. For others, Terry represents judicial surrender, a moment when the court abandoned its role as guardian of constitutional rights, when it prioritized police convenience over individual liberty, when it created an exception that has swallowed the rule. Both perspectives contain truth. The case is neither simply right nor simply wrong. It's complicated, ambiguous, caught between competing values that cannot be fully reconciled. Perhaps that's the most honest conclusion, that Terry versus Ohio reflects the difficulty of governing a complex society, where safety and freedom are both essential but sometimes incompatible, where reasonable people disagree about where to draw lines, and where any decision will satisfy some and disappoint others. The law is not mathematics. It doesn't produce elegant, provable solutions. It produces working compromises, provisional answers, frameworks that hold until they don't. And Terry has held for more than half a century, not because it's perfect, but because no one has figured out a better alternative that commands sufficient consensus. The case remains good law. Officers still conduct Terry stops every day. Courts still evaluate whether those stops were supported by reasonable suspicion. Defense attorneys still file suppression motions. Prosecutors still defend searches. The machinery grinds forward, processing cases one at a time, applying the standard Chief Justice Warren articulated in 1968 to situations he never imagined. And somewhere, on a sidewalk in some American city, a detective watches a person walking, notices something that registers as suspicious, and makes the decision to approach. The Fourth Amendment hovers in the background, protecting and constraining, guaranteeing security in persons, but not absolute security, prohibiting unreasonable searches, but permitting reasonable ones, forever requiring someone to decide what those words mean in this particular moment, with this particular person, on this particular street. The question will be asked again tomorrow, and the day after, and for as long as police patrol streets and citizens walk freely, and the Constitution attempts to mediate between them. Terry versus Ohio is not the end of the conversation. It's a moment within it, an important moment, a consequential moment, but still just a moment in a much longer dialogue about power and freedom and the role of law in a democratic society. The dialogue continues, the streets remain, and the Fourth Amendment, battered but still standing, still promises that citizens have the right to be secure in their persons against unreasonable searches. Even as we continue to argue, case by case, encounter by encounter, about what that security means and who gets to enjoy it. The evening settles over the city, the streetlights glowing steady in the dusk, the sidewalks carrying their silent traffic, and the law moves forward the only way it knows how. One decision at a time, one stop at a time, one case bearing one person's name into the permanent record of how we tried to balance freedom and order in a republic that promises both.